session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV140408, Hirsch et al. Versus the Arizona Corporation Commission. Council, we are recording today's proceedings, so when you step to the podium, please identify yourself and the clients that you represent. Each side will have 20 minutes for argument, and appellant's counsel is responsible for watching the clock and reserving any time for rebuttal that you might desire. We have read the briefs, and we've conferenced the case prior to argument. So with those preliminaries out of the way, Mr. Lavelle, you may proceed.
My name is Mick Lavelle. I represent all of the appellants. Just briefly, the Mortgages Limited problem has probably been talked about in front of everybody in this room at one time or another. The particular emanation that is in front of you results from Mortgages Limited needing money, Radical Bunny collecting money from various groups and investors, giving the money to Scott Coles and Mortgages Limited in return for a note. Scott Coles commits suicide. Mortgages Limited doesn't pay the money back. Radical Bunny doesn't have the money to pay its investors back, and this proceeding follows. It has now been determined that notwithstanding what Scott Cole did, that's not a defense for my people. They violated the Arizona securities laws in a couple of different aspects. They sold unregistered securities, and technically the commission determined that they were guilty of fraudulent misstatements and omissions. But that's not what this appeal is directly about. We accept the findings of the commission, although we disputed them below. For the purpose of this appeal, we accept the findings of the commission that we were inappropriate in our behavior and violated the securities laws. The problem comes from two different lines of cases. The first one came about as a result of the tightening or conservative bent of the federal court over the last 50 years. Over the last 30 years or so, federal securities laws have been tightened by court decision in a variety of ways. There's all kinds of pleadings that it once would have passed muster that wouldn't pass muster now. There are various kinds of liabilities that no longer exist or have been tightened down. The nature of damages recovery can be limited. What is important for us is that in 1996, presumably in response to this federal evolution of the law, the Arizona legislature passed a mandate and said, wherever possible, we want the courts to follow the federal law. Well, just how seriously that would be taken awaited the case of Gama v. Sell. In Gama, we actually had an old case that said aiders and abettors were liable. Supreme Court said, well, we don't think aiders and abettors are liable. Our Supreme Court came down and said, as a result of just the Supreme Court case, we're going to reverse our prior precedent and hold that aiders and abettors are not liable. The second case of interest here, and I think that shows just how powerful the legislature's mandate was, but the second case of real interest here is Grand versus Nacho. The Supreme Court, again, came down and said, you can see a twinkle in Justice Scalia's eyes, given what he thinks about class actions. He says, it's always been part of the law that proximate cause was a required showing in a securities case. And by proximate cause, They mean loss causation and transaction causation. You've got to show that the transaction was caused by the behavior, and you've got to show the loss was caused by the behavior. Well, obviously, if you were a class action lawyer on either side of the big class action wars, you thought that that was pretty interesting stuff as to what would have to be proved and the kind of various differentiations that could be made amongst members of a class. Arizona took one look at that in the Grand case and said, yes, we're going to apply that. Specifically quoted Grand and said, it is applicable to any securities claim, statutory or based in common law.
But that's in a private action.
Private action, correct.
Do you define
But it doesn't.
counsel, do you define this as a private action?
No, this is not a private action. It's a question of whether or not the Corporation Commission is going to be limited by the same doctrine. And I'm not here to tell you that this case is on all fours and controls your decision. The question is going to be, is there something about the way the Corporation Commission operates that it exempts itself from any securities language in Grand? And I think the answer to that is probably no. I'll tell you why I think that. In the prior case, in the Gama case, which was also a private action, the Corporation Commission came screaming in with huge amicus briefs trying to save implied rights of action. Obviously, they were concerned at the very least that these civil decisions were going to be limiting their powers as well. I think they do limit their powers. I think in order to make a finding of what caused the loss and therefore what would justify a order of what is limited under the authority of the commission, you need to have that kind of a finding. There's no finding in those records. There's no testimony about that. There's not anything other than this many people lost this much money. So the first point is that if they too have to apply proximate cause, loss causation, and transaction causation, they simply didn't do it.
But the federal courts have fairly consistently held that in an SEC enforcement action, loss causation isn't required, and our statute mirrors the federal counterpart, so I'm having trouble with your argument.
But the federal statute then goes ahead and doesn't award damages on that. It awards damages on the basis of well, I want to say restitution, but they had disgorgement is the word they use. And so when you lose a federal case, as we lost in the federal case, what the court goes on to say is that your damages are going to be whatever you benefited from your conduct. And so we never get to the question of proximate cause of the damage because it is handled by a separate remedy. And that's a pretty nice segue into the second part of the argument, which I think is independent of the first. The statute grants the Corporation Commission the power to order restitution. Obviously, restitution is a word of art. Restitution clearly, at the time the order was made, had both a restatement provision and an Arizona case that said we're taking the benefits away from the party conferred. Restitution may strip a wrongdoer of all profits. And in a state case prior to the statute, it was specifically said, Murdoch Bryant Construction Company, that it must be unjust for the defendant to retain the benefit without compensating plaintiff. When the legislature gives somebody a power like this, it doesn't mean for them to construe the power any more broadly than the power is construed at the law. And restitution clearly is limited to giving back what you got. There was
Counsel,
no.
is that true given 442032?
Yes.
Because that says it gives them the power to correct the conditions resulting from the act, practice, from the act, practice, or transaction, including without limitation a requirement to provide restitution as prescribed by the rules of the commission, and that's the Arizona Corporation Commission.
Correct.
They define restitution according
Well, I
to
don't
44.
think they can
Hey,
define.
let me finish my
pardon
question.
me.
They define restitution pursuant to 442032's empowerment to do so. Isn't that correct?
They have defined restitution. My point is that when the grant of power was made of restitution, restitution meant what the law says it meant, and the Corporation Commission was not empowered to broaden that grant of power. They could define how it works, they could define how to get there, they could issue rules and regulations about restitution and application for restitution and all the rest, but I don't think they could turn restitution into the ability to hang somebody. I don't think they could turn it into the ability to award more than restitution by its legal nature meant. And that's, you're right on the issue where the Corporation Commission and the plaintiffs are having the battle. Can the Corporation Commission change the word restitution to mean something more than restitution meant when the legislature gave it that power?
Well, do you believe that there is no circumstance where restitution is defined by not simply disgorgement of profits, but by the return of the money the investors gave?
No, I think if you take a look at the Arizona law, and particularly the Murdoch construction case, and you take a look at all of the restatement, and the federal cases, which are defining restitution and its companion remedy, disgorgement, there tried to be a distinction in the briefs as to whether or not disgorgement really had anything to do with restitution. It's clearly the remedy for restitution, and the restatement says so, that they come out and say restitution, disgorgement, unjust enrichment, all is centered on what the defendant received. He has to give it back. And that's what they have the power to do. Now, that's not the only thing they've got the power to do. They've got the power to fine us. They've got the power to order. They didn't do it in this case because it was probably inappropriate, but they've got the power to order us to buy back the security. They've got the power to do a lot of other things. But if we're just going to go order somebody to pay back something, it's got to be within the parameters of the traditional legal meaning of restitution. And I want to address just one little, what I think is a red herring. The briefs have pointed out that, well, my clients can be jointly and severally liable with others, including Radical Bunny. All true. But the limitations apply, and there was no evidence offered as to Radical Bunny either. In other words, there was no causation or transaction causation or loss causation offered with respect to Radical Bunny, just like there was none offered with respect to my clients. The word restitution means restitution no matter what the powers of the commission otherwise might be. And so either one of those things, in my mind, would result in a vacating of the award of $190-some million not dischargeable in bankruptcy against my clients. I'd like to reserve the remaining 6 minutes unless anybody has any questions right now.
Thank you. And Ms. Coleman.
Good morning, Your Honors. Julie Coleman on behalf of the Commission. Based on the plain language of the statutory provisions of the Arizona Securities Act, with respect to the element of loss causation and the remedy of restitution, and the Commission's application of Arizona law to the evidentiary findings of fact, with respect to the repeated violations of ARS 44-1991-82 by the Radical Bunny managers and Radical Bunny, the decision should be affirmed because the Commission did not act illegally, arbitrarily, or capriciously, abuse its discretion, and the findings of fact are supported by substantial evidence. With respect to the resolution of the legal issues involving the questions of law, the appellants urge this court to ignore the plain language of the Arizona Securities Act, as well as to act in contradiction with the legislature's explicit directives concerning the application and construction of the Act. First, the Commission is not required to prove reliance or injury as an element of enforcement action brought pursuant to 44-2031 or 2032-1 for the violation of either the registration provisions or the anti-fraud provisions contained within the statutory scheme. Some private party actions for violations of ARS 44-1991A require showing of loss causation pursuant to the plain text of 44-2082E, which set forth the requirements for security fraud actions involving misleading statements or omissions under Title 18 of the Act, and that section is titled Private Securities Litigation. That is the section that the Grand 1 Court, as counsel alluded to, construed. And I want to talk to that a little bit because counsel suggests a couple of things in talking about Grand 1 and Cell versus Gamma and what the courts were looking with respect to those two cases. With respect to Grand 1, the court was looking at whether or not loss causation was a requirement under the Arizona statutory schemes in private securities litigation brought pursuant to 44-2001 and 44-2003, as well as 44-2002. All of those statutory provisions are titled in a separate article of the Arizona Securities Act. And that article explicitly applies to, and expressly solely applies to, private party litigation. It does not apply to enforcement actions, which are brought under a different article of the Arizona Securities Act. And why is that important? Well, as counsel alluded, in 1995, Congress enacted the Private Securities Litigation Act of 1995. And in that act, the Congress set forth what was going to be required for purposes of a showing of damage or a cause of action as it related to, again, misreps and omission in a private party securities litigation concept and context. And why is that important? Well, because the courts have explicitly said that under the federal jurisdiction, that the private party cause of action is an implied judicial remedy. And what the PSLRA of 1995 did was say, okay, even in that context, we're going to require a little more of you. And that's essentially what they did, because here in Arizona, the legislature in 1996 did the similar thing by its invocation of Title 18. And in fact, those provisions mirror the PSLRA of 1995. Secondly, with respect to Cell versus Gamma, the Arizona Supreme Court refused to judicially imply aiding and abetting claims under the Securities Act when the relevant statutes do not expressly authorize such secondary liability. They didn't base their decision simply because the federal court in passing, the Supreme Court in passing Central Bank had made a determination that under the federal scheme there isn't implied. It was twofold. What they said was our legislature was silent, and because the legislature expressly declined to add aiding and abetting liability under our statutory scheme in 1996, it wasn't going to do that here by judicial implication. So it was dualfold. They said, the court said in Cell versus Gamma expressly that the legislature did not say we could do this. And even though the commission, for policy reasons, said to them, we do believe that we should be able to retain this implied right of action, they said, we're not going to consider policy, go to the legislature. That keys into something else that's relevant. When the Arizona legislature in 1996 passed its sweeping modifications to the Arizona Securities Act, it did not include a parallel provision to 44-2082E. That's the only place in the Act that has loss causation as an element of an offense, to regulatory actions. It limited it expressly to private righted action. If it intended to include that requirement in a regulatory action, it would have done so at that time. It hasn't done that. Secondly, with respect to Grand 1, it's a little problematic that appellants argue that the Supreme Court of the United States ruled as a matter of law that loss causation is equally applicable to every securities claim. While they use that quote in their brief, what they do, though, is ignore the entire paragraph from which that quote comes. What the court said specifically was, as discussed above, Dura does not significantly restrict the means by which a plaintiff can show proximate cause. It only clarifies that merely alleging an inflated purchase price is insufficient to do so. The Dura court also noted that judicially implied private securities fraud actions resemble common law deceit in misrepresentation documents. The reasoning of Dura, therefore, is equally applicable to any securities claim, be it a statutory-based or common law, because any such claim for damages requires a showing of proximate cause. In this context, the court is talking about judicially created implied rights of action. And in this particular portion of the brief, and that's at paragraph 67, the court is addressing the claims of the trust that dealt with common law actions for consumer fraud, as well as common law misrepresentations and omissions, rather than construction further of what is expressly required under the ASA scheme. Okay. As noted in Cell versus Gamma, the Arizona Supreme Court reiterated that the plain language of the ASA prescribes the available remedies and categories of potential defendants and articulates the elements of securities fraud. The legislator made a task of proving that fraud much simpler than proving common law fraud. The 9 elements of common law, found one of which is the existence of damage, is not essential to establishing securities fraud. Now, that was the Arizona Supreme Court in Davis. And to the extent now that the legislature has spoken to that issue with private rights of actions, arguably that portion of the opinion has been abrogated. But it hasn't been abrogated in its entirety, in part because the legislature declined to do so. Okay. Goes on to my next argument. Second, the plain language of ARS.
Before you leave it, so to sum up your point is that some of the restrictions we're talking about, including requirements of showing approximate cause, arise not in statutory cases but in common law or implied actions?
The statutes come out of, the restrictions come from Congress's looking at the judicially implied private cause of action under Section 10 of the 1934 Act, which is the Exchange Act of 1934 on the federal level. Once they have done that in response to litigation, the court then determined that Congress passed the PSLRA requiring heightened pleading requirements. And the Dura court really looked at it in terms of, what do you need to say? You just can't allege loss causation. You have to be able to prove it. But again, it was in construing the provisions of the private right of actions. Nowhere did Congress address the long line of federal cases, including Blavin, that said those requirements of loss causation do not exist in an SEC enforcement action.
What about Mr. Lavelle's point that, well, the remedy's different in those cases because it's disgorgement versus restitution?
Again, as to the issue of disgorgement, the SEC was not statutorily authorized to seek disgorgement until 1997 by its Penny Stock Reform Act. Where the disgorgement concept came from was a judicial remedy when no other remedy at law existed. Again, it's an implied remedy where there's no adequate remedy at law. Here, under 44-2032-1, we have express statute authority to correct the condition resulting from the act, practice, or the transaction.
Well, it strikes me that 2032-1, since we're talking about it, is inclusive, is it not? It authorizes an order that the person take appropriate affirmative action. And then it says, including without limitation, restitution. I mean, do you make something of its apparently inclusive or open-ended nature? It doesn't say only these orders are permitted. It says an order is permitted that directs the person to take appropriate affirmative action, which seems like a fairly broad term.
I would agree that it's a very broad term. And doesn't
it also direct the commission to establish its own definition of restitution?
What it really gives guidance to is to establish a method by which the commission can correct the condition resulting from the act, practice, or transaction. So in that sense, you can use the term definition, but I think that the remedial measure is broad, and they gave the commission its authority as the agency that is charged with implementing the statute, and said, we're going to continue to give you deference in your promulgation of your rule. And that's an important point, because that particular section of the Act, 44-2032-1, has not been changed since it was enacted in 1951. Interestingly enough, too, the commission promulgated its rule originally in 1987. At the end of the year, in May of 1988, is the first time the commission began ordering restitution pursuant to its rule, which is a essentially damages rule, which allows full restoration of the investor rather than.
Counsel, is that in the Administrative Code section R14-4-308C1?
Yes, Your Honor, that is AAC R14-4308.
So if we can put that in context, it says if restitution is ordered by the commission, 1A says the amount payable as damages to each purchaser shall include cash equal to the fair market value of the consideration paid, determined as of the date such payment was originally paid by the buyer. Is that correct?
That is correct.
How do you define that? How has that been defined?
It has been defined by the amount of money that the investor has given to the individual.
In this case, the participants have given to Radical Bunny.
They've also has been construed to equal the amount of money that was raised by individual persons under the Act.
So it's not just the individual I hesitate to use the word contribution, but you know what I mean, I'm sure. It's not just the individual contribution, but it's actually the entirety of the contributions and the persons who've made them.
Correct.
Thank you.
And to that end, and that goes to the heart here, appellants argue that they should not be held liable for monies in which they didn't personally profit. But what the statute says by its clear language is that they should be accountable for what they raised in violation of the statute. And here we're talking primary liability. And here the commission found specifically that they all engaged in action that violated Section 44A2 with respect to various representations and omissions. I'll get to the next point. It also held that they were secondarily liable for the same anti-fraud violations that Radical Bunny committed with respect to these individual investors. So there's two levels of liability that the commission found in this case when it ordered that they pay the balance due to the non-managing participants under its order. Okay. Now, counsel said that they agree with the commission's findings of fact for purposes of this appeal. Yet their brief actually asked this court to reweigh some of the evidence that the commission considered below. And that is specifically in reference to the commission found that the document entitled "The Direction to Purchase" was provided to every account holder between May 2007 and June 2008, and that it contained the language, "Your investment is collateralized by the beneficial interest under various deeds of trust held by Mortgages Limited." And that's at the decision at 186, 5 through 7. They take issue that the commission didn't show that this was related to every single investor. However, it is undisputed that every investor received that same direction to purchase. And the commission also found that by omitting the fact that the collateral was in question from 2007 in May all the way through June 2008, that they committed a material misrepresentation or omission of the act, vis-a-vis all 900. So to that end, the calculation of the penalty, in addition to the amount of restitution, the calculation of the penalty would lie to 900 separate violations of the act with respect to just that one misrepresentation and omission. Just that one. And that's just for sale. The act also allows for the award of penalty for the offer. So technically, with each account holder in each rollover and new investment that occurred, you could get two. So in this case, just the one violation for the sale alone the commission could have assessed penalties then against each one of those, for each one of those violations up to $4.5 million. It didn't do so. Instead, it used its discretion and did a cumulative based on varying amounts of culpability of the individual respondents up to $4,650,000. So in sum, the commission's position is that the issues here before you can be resolved simply by the plain meaning of the text of the statutes at issue, and as well as giving deference to the factual findings in the record, and as those factual findings are applied to applicable Arizona law in a regulatory enforcement action. The court has any questions?
No, thank you. Rebuttal, Mr. Lovell.
Thank you. I've got a lot to cover, so I'm going to go kind of fast. The first thing that struck me about the response to questions about, so hasn't the commission made restitution anything it wants to make it is that's not what is required. Under the Arizona Constitution, the legislature has to give specific powers to the commission. It can't just say, why don't you decide what all crimes you're going to cover? Why don't you decide what all penalties you're going to issue? Why don't you decide how you're going to get around to this? It said restitution. Nobody has contested that restitution had a standard meaning, and nobody contests that the Arizona rules turn that standard meaning on its head.
But you will admit that it's defined.
It is defined.
The issue of what may constitute restitution was directed by statute to be created by the Arizona Corporation Commission. They did so, and they have an administrative rule, and they say this is what is inclusive of restitution. You agree with that?
Almost. They have a rule that says restitution is determined by what the party lost, less anything else. It can get more technical than that. But that's not the law. It would be as though somebody said, Judge, you can sentence from 8 to 10 years in accordance with whatever rules of court you make.
Or would it be you can sentence according to whatever guidelines are applicable to that situation? Because that's what we do have.
That's right. But the guidelines here are the law of restitution, and you can't get outside of that parameter. And that's where I think it went wrong. I think that, yes, the Corporation Commission has issued rules, but it has issued rules that fly right in the face of the meaning of a grant of restitution. It's turned it on its head. And the question is, okay, if the legislature says restitution, can the Corporation Commission say, oh, not restitution, we want damages, we want total loss? That's not what restitution means.
So if restitution has been defined as the Corporation Commission did in the administrative code, that would poke a hole in your theory that they couldn't have done here what they did, correct? I mean, restitution may not always be the same thing.
If that regulation trumps the law of restitution.
What law of restitution are you talking about?
When you say restitution, you are talking about what the restatement says, which is that it is it's an unjust enrichment kind of theory. And it is also taking care of the Murdoch construction case, which is prior to that, which says restitution can only be issued to get money back that the wrongdoer has. That's the only way restitution works. And that's not so different.
Does that interpretation read out the language as prescribed by rules of the commission? I mean, if they just put a period, I'm looking at 44-2032-1, it says, including without limitation, a requirement to provide restitution as prescribed by rules of the commission. I mean, if they had just put a period after to provide restitution, I think your argument would have stronger effect, but doesn't that as prescribed by the rules of the commission confer on the commission some fairly substantial discretion?
I think it confers on the commission the rules to effectuate restitution as restitution means. I do not believe it gives the commission the power to change the meaning of restitution as understood by the legal system for a good substantial period of while, and it has continually been the measure by which securities restitution is undertaken in all of the federal courts. So if the commission says, well, we're doing it differently, what do we do with the mandate of 1996 and the idea that we're going to be like all the federal cases, and you can see them in there and nobody contests them, say, no, we're going to take the amount by which the wrongdoer benefited. And so now suddenly the commission has carved out an exception to itself. I agree with you that the issue is that regulation legally appropriate? If that regulation doesn't fail, then my theory has terrible trouble.
Counsel, when you say that we're going to do this according to what all the federal standards are, which I believe is what your comment was, right?
Right.
I was reading in Cell versus Gamma, it says, in interpreting a state statutory scheme such as the ASA, this court will give less weight and not necessarily defer to federal case law that construes a parallel federal statute when the state and federal statutory provisions or their underlying policies materially differ. It goes on to quote Bunkers Glass Company versus Pilkington to say, as declining, quote, to rigidly follow federal precedent on every issue of antitrust law, regardless of whether differing concerns and interests exist in the state and federal systems. And because doing so would thwart the Arizona legislative intent and would not necessarily achieve uniformity. So doesn't even Cell versus Gamma indicate that we'll separate ourselves from federal from strict compliance with federal standards where the state's interests differ?
True, if the state interest really does. But we've taken it so far as to eradicate a previous decision in light of the federal change. We've done, so far, all of the federal changes that have come up before the court have been endorsed. Our case law and prior law has been changed to impose those rules. And what is going on is the very same thing. The SEC is controlling federal securities law and penalizing those who violate it. And they have the right to take the money the people got back. There's no different motive for the Corporation Commission. They're trying to do the same thing, and they ought to have the same tools, and they shouldn't be able to define their tools so that they can have a broader power than anybody would have ever thought was meant by the word restitution.
Thank you.
Thank you. Thank you both for your arguments. We will take this matter under advisement and issue a ruling in due course. And at this time, the court stands adjourned. Thank you.